Welcome to our industry update for the month of May. I'm Jill Cox with Chicago Title. Thank you for being our guest. And real quickly, if you find value in these updates, we would love an opportunity to close one of your upcoming listings at Chicago. And today I am super thrilled to present our two guest speakers, Mr. Scott Peterson and Damian Cox, two Colorado real estate attorneys who really need no introduction. As many of you know, they joined forces this past November and they are now their own law firm. So Cox Peterson LLC. So thank you so much for joining today. They are going to cover a wide variety of topics that is just a quick update in the world of real estate and what's going on. So with that, I will turn it over to you gentlemen. And if you guys have questions, just throw them in the Q&A and we will address as many as we can. There's a lot of you on here today. So thanks for being here.
Well, this will be fun, Scott. We got all sorts of fun stuff to talk about and joining
Yeah,
forces.
joining forces. Yeah, that was November, and we're not in divorce court yet, you and I, Damian. So that's good, I suppose.
That is
Uh,
surprising too, to be honest, but
well, we have such good communication, and we just let everything off our chest. So it's an important part of a relationship, I'm told. But yeah, it's good. Just I mean, I think most people that pay any attention to kind of what I've been up to are aware of that, and it's been a fun several months, and it's been good in the sense that I've been able to work with Damien to take on some new clients and also, continue to provide legal services to CAR and my previous capacity in much the same way. And so, and actually our firm does. So technically it's Damien and I both. And so it's been a fun evolution of things and enjoying it, at least on my end. Damien might privately, Jill probably knows the real answer to whether Damien enjoys it or not, but so far so good for me.
well, I guess we should probably actually kick off with some content, Scott. Do you want to
Yeah.
roll into some antitrust because we want to make sure that we put everybody to sleep right off the bat?
Because I feel like I talk about antitrust too much, and it's not because I like the topic, because it is a very boring topic. But just very briefly, and it's I don't mean to beat dead horses, but we still have a handful of things kind of going on from a litigation standpoint nationally that is all kind of related to antitrust. And I think most of it is kind of winding down, which is a really good thing, I think, for the industry. But just very briefly, a couple of things. The first thing that I'll mention is that the seller lawsuits, the big judgment or verdict, the settlement, the practice changes, all of the seller lawsuits will say that where that settlement agreement was approved by the court in November of 2024. As some of you might know, there's a handful of people or small groups that are essentially appealing the court's approval of the settlement agreement. And they're appealing it for a couple of reasons, a couple of primary reasons. One is they say, and I think we can all agree with this, that the lawyers are making too much damn money from that settlement. In other words, the sellers are getting, peanuts, literally, and the lawyers are getting, upwards of $400 million in terms of settlement. And so they're appealing the approval, the court's approval, the district court's approval of the settlement agreement on that basis, as well as they're saying, in fact, that this settlement agreement and the practice changes are actually harmful to buyers because buyers are obligated now to enter into a written agreement with a broker before they can, they gotta get married before they can date, kind of principle. In other words, that practice change, at least this segment of people, appellants, are saying that that's not good consumer protection kind of for the buyer. And so those are the two main points. That appeal was made to the Eighth Circuit Court of Appeals. They heard arguments, the three-judge panel heard arguments in January, kind of end of January, earlier this year. And they expect that there'll be a verdict or a decision rendered by the Eighth Circuit Court of Appeals sometime at the end of this summer or in the fall that will either uphold the approval of the settlement agreement or it'll overturn it, God forbid, because it'll create just havoc because we've already implemented everything. I mean, the contracts have been changed. The MLS has, eliminated compensation. Practice changes have been implemented. The checks have been cut, by all of the respondents and settling parties to the plaintiffs. And so it would really be a difficult situation if they do overturn it. by and large, the legal commentary, at least that I've read, and this is not my area of expertise at all, but it's a pretty high bar to get it overturned. But be paying attention for that as we get into the end of summer and beginning of fall, and hopefully the Eighth Circuit upholds the approval of the settlement, as I hope they will, and that is really behind us on the seller side. The buyer side lawsuits are winding down. I think there's three. There were three primary buyer side lawsuits. The same concept of the sellers, only that in this case the buyers were harmed because the compensation that allegedly you guys had inflated to harm consumers. While if it harmed the sellers, then we know that some level that compensation is passed through and the buyer ends up paying that. And their claims have never been as attractive as the seller claims, from the standpoint that they didn't actually pay the commissions, And so the courts has, I think, been a little bit dubious of these three lawsuits. But nonetheless, they are settling out now. And you guys have maybe seen in kind of the, Inman's and, other, wherever you get your real estate or industry news. I think Remax has settled for, I don't know, 10-ish million, Keller Williams for 10. I think NAR settled out for like 52 million. And a handful of other brokerage firms have settled the buyer side lawsuits. Now, it's still got to go through the process. Those settlement agreements are going to have to be approved by the court, just like the seller side was. And so there's still, some hurdles to come across. But my guess is those will face far less scrutiny as a general rule. And there are no practice changes that are implemented as part of those settlement agreements. In other words, that's just purely financial. And once again, lawyers are going to make some good money, and the buyers who were harmed will get, they'll get back a check for 18 cents or something like that for the harm they've endured. And so those are the buyer lawsuits. Damian, before I move on to a couple of the other things, you want to say anything?
No, believe it or not, I have nothing to say about this. I'm so tired of antitrust, I can't even tell you.
If I just keep firing words out, then it keeps Damian quiet, which I think is very satisfying for probably everybody, all 155 of you. Most, however, satisfying for Jill. She doesn't have to listen to him talk here. The other stuff that's going on in kind of that antitrust, or explicitly the antitrust realm, is the PLS.com, which was a lawsuit that was filed back in like 2019 or maybe 2020. And it was related to the clear cooperation policy and NAR's policy about having to put your property on the MLS within one business day if you do any public marketing. They were sued by the PLS and one other group, Top Agent Network, back years ago, and basically saying, hey, the clear cooperation policy, it's harmful to consumers because our business model can't be implemented. And so the private listing service is a network where brokers from different brokerage firms are invited to join or may join this thing. And they kind of trade, for lack of a better way of describing it, kind of pocket listings, right? They're pocket buyers, pocket sellers, and they say, hey, I got a buyer for this kind of property, and I got a listing that's coming on the market. And obviously the clear cooperation policy put a fork in that. And so that's why they sued. And NAR and those two other plaintiffs, Top Agent Network and PLS, they all withdrew from the lawsuit. And they did that because NAR decided to do the amendment to the policy to expand, or to, I guess, narrow the definition would be of public marketing. And so they eliminated, or they created the ability of a broker to do one-to-one marketing, and it's still not public marketing. This was a year ago, March, basically. And the reason NAR did that was because they wanted to basically appease, well, for a couple of reasons. One, the private network or private listing stuff, which we'll maybe get into a little bit later, and that brokerage firm business model, as well as to buy off or beg off the Top Agent Network and the PLS. And it worked. They all withdrew from the lawsuit, and no settlements, no verdicts, no nothing. And then NAR announced the policy. And then about 6 months later, which would have been the end of last summer, the PLS actually refiled their lawsuit out in California. And so they're now pursuing that. So the clear cooperation policy is still being challenged from an antitrust perspective. Again, we're probably 18 months or so away from having any kind of results in that, but do stay tuned. And the last one I'll just very briefly touch on was the first matter that was filed was a matter called Hardy, which was in Michigan. And Hardy was a realtor in Michigan who was forced by policy that basically said he was in a closed MLS, for lack of a better way of putting it. And basically the MLS said, hey, if you want to join the MLS, then you also have to join our realtor association, our local association. It's got to be a realtor if you want to play in the MLS. And that's still a policy even in Colorado and a handful of MLSs. And although most have kind of switched to what we would call an open MLS. But Hardy sued NAR and said that, this is, or sued the local association, sued NAR, sued the MLS, and basically said, hey, this policy is collusionary and it's harmful to me as a consumer. And that lawsuit was dismissed about, I don't know, 2.5, 3 months ago now. And so there is some other similar litigation that's percolating around a little bit. But I think, as I alluded to just a second ago, I think most MLSs are actively in this discussion. And I don't just mean in Colorado, I mean nationwide, actively in this discussion about, are we willing to continue to remain a closed MLS? In other words, we're only open to our realtor members and risk potential antitrust allegations, or are we going to open up and allow anybody to join and become a member? And those are kind of the 4 things that I just wanted to give a quick update on, because all of them, again, involve the basic concepts of antitrust. But the good news is, as a whole, like, as you can see, like, the real seminal stuff is very much, I think, winding down. Now, we could spend another little bit at some point, if we have time, talking about all of the data war lawsuits and Compass suing Zillow and Zillow suing Compass and some of the things that have occurred there over the last 6 months or so. And in fact, the Zillow versus Compass / IMRED lawsuit was just filed about a week and a half ago. And you're going to be hearing an awful lot about that. In fact, as a fallout of that, Zillow just pulled all IMRED listings down off of Zillow. And that's like all of Chicago. And like, it's one of the largest MLSs in the country. And so that's part of what I'll broadly describe as the data wars that I think we're on the very front end of. And so stay tuned with that. I'll shut up now, Damian. You say something.
Well, I actually want to go back to one of those. I mean, the data wars are certainly interesting. It's going to be interesting to see how that plays out. But along those lines, between the data wars and the PLS, we have that clear cooperation. We have those, was it the preview listings that I think Zillow has launched? Compass has a similar model with its connection with Redfin, I think, that it put in place. And it's all about having these listings that don't go on the MLS first and have this marketing. And I think we probably ought to talk about it, even though it has nothing to do with antitrust. And frankly, the PLS lawsuit, depending on how that comes out, could affect what happens with those things that as they stand. But I think we should probably discuss where things stand today with the previews and I can't remember Compass's what that one was with Redfin.
Private exclusive.
Private exclusive, yeah. Just talking about what that looks like, and I think there's some things that people need to be aware of on that. I mean, I think the Zillow one actually pays people for putting their listings up, which creates this potential conflict of interest. The question will become: did you enter into this agreement because it was the best for your seller, or did you do it because of your own beneficial interest? And I think you can make that argument for really either one of those systems, depending on how you look at it. And I think I haven't seen any of those complaints come up. I don't imagine you have, as far as with the division of real estate. But my take on it is there's going to be some analysis of that, of, well, what was the motivation for doing this, and was it really in the best interest of the client? Was it fully disclosed? And is there a conflict of interest? And what did you talk to your seller about when you did this? And all those things that I think are worth answering. I don't have any answers for it. I think people need to have it on their radar. Scott, you have any thoughts on that part? And then we'll talk about the other issue, which is going to be the MLS rules.
Yeah, I mean, so a lot of people ask me, like, oh, what does the Division of Real Estate feel about clear cooperation, or what do they feel about private listings, or whatever, whatever nomenclature you want to use to describe the marketing strategy. What does the commission say about this? And the reality of it is, I think the commission would say, or the division would say, that from a regulatory standpoint, broadly, they don't care. In other words, that businesses are going to do business if they want to do business, and marketing strategies are all fine and well. They're focused exclusively on one thing, and that is, what is in the best interest of the consumer, and is all the things that are being carried on in the consumer's best interest. And so I think that any brokerage firm or broker who is doing something that is less than sort of full or broad exposure and certainly I know any of the big companies who are doing some of that, that they have in place, very explicit and well documented, well reviewed, disclosures, language that expressly, gives to the seller consumer a very clear kind of, here's the benefits of our marketing strategy, here's the risk, so you understand the implications of all of this, and that they're signing off on that with eyes wide open. And so I would, well, I'm very comfortable saying that any company that is really leaning into those marketing strategies, and I think we're going to see more because we look at the mergers that have occurred over the last 6 months. I think that on some level, at the end of the day, every merger is about creating efficiencies and those kind of traditional things, and maybe new synergies, and I think there'll be some of that from all of this. But at the end of the day, and why I call them data wars is because people are seeing that the larger or bigger aggregate of data you can control. By that I mean listings and buyer seller information, data, listings. All of that stuff is king in this modern technological world that we live in. And so that is I believe at the heart of why the consolidation has become so aggressive at this point. Right? They're trying to build and build, build. The more data you can control, the better you can leverage it, whatever your marketing strategy is. And so all of that, I think, could come under some scrutiny. Again, depending on, at least from a regulatory standpoint, is what is in the best interest of the consumer, and is that why you're doing that? So we'll wait and see. And this is a topic that we're at the very front end of this whole discussion as an industry. And I think we've had questions, and I think Carr's kind of taken a position. I know that they've taken a position that is essentially, we're going to monitor kind of what happens over the course of the next several months, and determine, from a legislation standpoint, see what comes. I think some of you guys are probably aware, this, like the state of Washington, as an example, passed Senate bill, I think it's 6091. But they passed that. It goes into effect next month, and they basically, banned public or private exclusive, or any private marketing if it's a residential property in the state. It doesn't have to go on the MLS, but it has to be made broadly available to everybody. And so, I guess we're going to see kind of what happens over the course of time, and determine, what the different stakeholders and different industry participants are planning on doing. But I keep coming back to this one fact that, the bedrock of our industry, for you all, regardless of the marketing strategy that you use or the business model that you might use or employ, the bedrock of the industry is cooperation and collaboration and all those good things. And at the end of the day, I think that's, regardless of whatever business model somebody might intend to employ, that's going to be what we as an industry should be coming back to on behalf of consumers, because it's been a critical piece of how things have operated for a long, long time.
I actually saw an Inman article, and I can't remember the data on it, but it was essentially saying that in-house listings or not publicly marketed listings sell for less than publicly marketed ones. And as that data, I don't know how accurate it was, I can't remember the source of it, but if those kind of data points start coming out, you can see where there's going to be this huge war over what is or is not good for the consumer. Because the arguments right now are being made that, and you made a good point to me yesterday, because I've always been a big fan of cooperation and MLS, and I think it really is something that's very important to our industry. But the days on market is an interesting nuance of the argument that days on market harms sellers, and frankly, I can see the argument. So it's going to be interesting to see what comes out of this as it goes. But what also is concerning to me, or at least I think brokers have to be aware of, is that as these programs become available and people start looking at them and deciding whether they're going to participate or not, and whether, and frankly, maybe it's an open conversation with your seller and they say they do want to participate. Maybe there's reasons they want to. They don't want open listings. They don't want everybody coming through their house. They don't want, whatever the case may be. There's certainly could be reasons that a seller does want these kind of programs. But then, we still are running afoul of that clear cooperation. And I think brokers need to understand that is going to play into this decision. I mean, don't you think, Scott?
Well, it depends on how it's extrapolated. I think that office exclusive in connection with one-to-one marketing is an exception to public marketing. Therefore, I don't think the MLS clear cooperation policy is invoked. And I think that's how the vast majority of brokerage firms that are using private exclusive networks, or they're privately marketing within the firm, and even in a broader network, it's not being done publicly, or it's being done on a one-to-one basis, or not being done publicly, and therefore it's not such an issue. The Zillow preview thing, I think, might be a little bit different. In fact, I mean, based on my understanding of it, I'm a little bit confused about how that might work, because that's done on a broadcast basis. In other words, anybody can go, if they go through Zillow, they could go see this Zillow preview. And that's not one-to-one marketing, I don't think. And I don't want, they maybe have looked at how they're rolling this out and have gotten a legal opinion, or MLS opinions that say that it's just fine. But that one is a little bit different, because I don't think they're doing anything on a one-to-one basis. And so from my perspective, if they're putting it on like a Zillow preview, I think that listing broker would have one business day to get it active or listed on the MLS based on their MLS rules.
Yeah,
again,
other portals that they're doing like that, depending on how they're rolling it out or what that looks like. Is it a one-to-one or is it not, whether it runs afoul? I mean, I'm just, like I said, I don't know. I don't want to make opinion on any of these, because I just don't, first of all, I don't think it's my place. And second of all, I don't know enough about it to know how. Did I just mute myself and I've been talking and nobody's been
no,
listening?
you're good.
No,
Well,
but
we
I
can
think
hear you.
your cord maybe came out of your microphone, your big mic.
Got it. Great.
Okay.
So, okay. So yeah, so I think the one-on-one is just that's going to be the question. And I don't know how these are being rolled out, so I have no idea as to whether or not they're taking that in consideration, or what the MLSs will do with it. But I just want to flag it for brokers, because I think you guys got to be aware that it could be a potential issue if something goes astray later on.
Yeah, it's just like I say, you're going to have something that is sort of irrefutable, that the seller understood, the decision they were making as they were employing whatever marketing strategy, they're authorizing you to deploy for the property. And I don't have a judgment one way or the other on the validity or whatever the business models, and we're going to see it evolve in real time over the course of the next several years. And it's certainly an interesting time. The mergers have come pretty fast and furious, and I sort of predict. And again, I think one of the primary drivers of that is aggregation of data and information. Another primary driver, I think, is timing, and I still think we're going to see at least maybe one or two more, and partially because I think that there's a belief that maybe they'll have a little bit less FTC scrutiny, with the current administration and kind of current perspective on the FTC, and having just approved the Compass Anywhere merger, which is nothing is going to be in terms of putting two entities together as big as that one at this point. There's just nothing, it's just not, there's not enough left to do that. I suppose you could aggregate a bunch of different brokerage firms, but I think that there's a sense maybe among the folks that are like, really serious lawyers who represent these kinds of folks in front of the Federal Trade Commission and help companies go through the scrutiny that goes on there, that this is going to be as good a time as any to get things through the FTC in terms of approval. And so I think there's a little bit of that going into this too. And we will see more of that over the next, like I say, 12 or 18 months, with some certainty regarding, how relative certainty regarding how the FTC might react to these proposed mergers. Did I just get us way off track?
No, I think that's a good point. I mean, I think there's a lot of things that are playing into the mergers right now, including a down market and the NAR settlement and all sorts of things that have really shaken up our industry. But yeah, I don't know as I have anything more. Do we have any questions on that,
There was
honey?
a
Or
question, yeah, from Eric that popped in. Let's see. So he says, from what I recall on the NAR settlement, the practice change agreements were only required for 3 or 5 years. Do you think that at the end of that time frame that things will revert back to the practices we had before the settlement, or does it open everything up for new or additional seller lawsuits looking for more money?
wouldn't that be fun, Scott? We could revert back. Everybody could say, okay, let's go ahead and put compensation back in the MLS so we can get sued again. That sounds like a
Yeah, no, I don't think you're going to find an MLS, or really probably any portal, any
or anybody.
information exchange or portal, whatever you want to call it, is going to be probably willing to touch that third rail going forward. And I think it was 7 years, I think is what the practice changes were in place for. You're stretching my little mind, but I think it was a 7 year agreement that those practice changes needed. The only one I think, we'll see what happens with the buyer broker agreement. I will say this is another thing that you guys, and I know Brian Tanner, who is with Carr, the government affairs vice president, and the state legislature just wrapped up. Yeah, he's coming on next month.
Or next month?
Yes, he'll be our guest next month.
Yeah.
And what date is that? Do you have a date or?
We are still playing around with the date. So
trying to do a plug. Are you stepping on my appearance, Damian, with a plug of somebody else? Is that what's going on here?
I was going to plug. I mean, Carr did some wonderful things in the legislature, and I think it's very important for everybody to tune into that, because there is a lot of stuff that went on, and I know Scott's going to try and steal some of his thunder now by talking about a couple things. But so go ahead and steal his thunder. It's okay.
No, I don't think I'm going to steal his thunder. But the thing that passed very quietly and quickly at the very end of the legislative session, and I mean like the day before they adjourned last week, I think it was the Department of Law, which is essentially the Attorney General's office. They ran a bill, very comprehensive. It was like a 70-page piece of legislation, and it touched a whole bunch of things. But as it relates to division of real estate, one of the changes that they proposed and passed was that we are going to have in Colorado mandatory written buyer agreements. And that was passed. I don't know that it's been signed by the governor, but I have every expectation that the governor will sign the AG's bill. I mean, it is the AG's bill. So the bill will get signed. And this will be the case. I couldn't tell you right now whether it go into place in August or September, or like 90 days after it's signed by the governor, or if it goes into place January 1st. I don't know off the top of my head. But there was 3 pieces that touched real estate. One of those pieces was that when it becomes effective, it will be mandatory. You will no longer be able to default into a transaction brokerage relationship through a disclosure. You'll have to enter into a written agreement, much like you do with a seller in Colorado, and have for years. If you want to work with a seller, you got to have an exclusive right to sell listing agreement. It'll be the same with a buyer, and that was not something that the real estate industry ran or did anything with. It was something that was initiated by and run by the Attorney General's office. And that's a change that's coming. Now, it's going to be up, once that bill is signed, it'll be up to the Division of Real Estate to work with the commissioners to implement the rule related to that. But my guess is it's going to look very similar to the current rule, or the rule we've had for years with sellers. And so,
and honestly, that's a good thing. I think I personally think it's going to cause a lot of turmoil for a lot of brokers. That goes back to the questions with the NAR settlement and the claims that it doesn't go for buyers because they can't date and they have to sign things first. But at least it makes it consistent with the NAR settlement, which I kind of like.
Yeah, that was one of the primary points of confusion that we dealt with for the better part of a year and a half, was like, well, wait a second. The division says you don't have to have a written agreement to work with buyers, and the NAR settlement says that you have to have a touring agreement. And this, again, this was something that was unilaterally initiated by the AG's office. And anyhow, that's coming, and I agree with you. It's a good thing. I mean, I tell brokers all the time that exclusive right agreements are vital. You guys work way too hard, and I hear way too many horror stories from brokers who are like, I just spent 6 months running this buyer around on my weekends and evenings, and all just found out they closed with another broker, and what can I do? And my first question is always, well, did you have an exclusive right to buy? Did you have a written agreement? And too often the answer is no, or gee, I trusted them, and they were so nice, I never thought they'd do this to me. But at the end of the day, that agreement is, you deserve it. You work too hard for it. You should get it. And this will, I think, memorialize that expectation.
Well, and being able to tell the buyer, I'm sorry, but it's Colorado law, will make it a little easier than them saying, well, I don't want to sign anything, I'm not committing. Well, it's Colorado law. Any broker you talk to is going to be required to do it. It's going to make it a little easier.
Yeah. You'll still have those who won't do it, though, Damian.
Yeah, we'll still have those that don't. And then, yeah, well, that'll be another.
Happen to those brokers who don't do that.
The bill actually has some teeth. It's a little scary, but
Yeah, it's a violation of the CCPA,
Yeah, I mean that to
Colorado
me it was a
Consumer
little
Protection
over
Act.
the, which is a little over the top. I mean, and for those of you that don't know it, I mean CCPA is a big deal for those of you that don't know. We're going to talk, I think, probably a little bit about that here in a minute when we talk about Colorado Foreclosure Protection Act. But CCPA claims are nasty because number one, the Attorney General can enforce them. It's not just a private action. Number two, it's like triple damages if you violate it of whatever those damages could be. I think there's like jail time attached to it. And more importantly,
Mandatory attorney's fees.
mandatory attorney's fees. And then my personal favorite is there's no E&O insurance. So every single one of your carriers won't cover a CCPA violation. So CCPA is a big, big deal. If you hear that come up, which it's come up several times in the last several years, that of people trying to change the CCPA that Carr has been successful in beating back, you need to pay attention to that one because it will impact your business. And this one, I don't know why they made it a CCPA violation, but they did.
I think there was a number, as I mentioned, there was a whole, it wasn't just real estate was only maybe a page out of this 60 or 70 page bill. There was a lot of other industries, and I think a lot of them did invoke CCPA tie-ins, basically. And so I think it's reflective of a more heavy-handed or more heavily regulated, perspective, or from the Attorney General's office. I think. I mean, it doesn't surprise me that they're trying to create more avenues for Consumer Protection Act claims.
Yeah, and I mean that's obviously what it's for is consumer protection, but it's it seems a little heavy for what it is, but it is what it is, and you're going to see changes to it, and you guys are going to need to be aware at some point that's going to be a requirement.
We had a
Do
question
you want
come
to?
in.
Oh, go ahead.
It was, can you discuss MLSs and any overarching requirements that dictate, for example, if you list a property in Colorado Springs, you must input it in PPAR, repercussions if not done. Would love to see a state MLS personally. Zillow has better data than any one MLS. What's the point?
This is not that they have an opinion on what the MLS rules should or shouldn't do, but
Are they saying that there is a rule that says you have to list it in the market? There's an MLS rule that says if it's in that market, you have
I'm
to list
sure
it on the
that's
MLS.
well, I think it's more that if you're a member of the PPL MLS or whatever PPAR, whatever it is, that
PPAR.
you have to list it within a certain time. It's clear cooperation. That's what they're talking about here. This is the MLS rules that by virtue of you being a member and signing your agreement to get access to the MLS, you agree to their terms of service. And one of their terms of services is that if you have a listing in their area, then you have to turn it in within so many days of taking the listing. So that is exactly the clear cooperation thing that we're talking about. That is a requirement, and they're not the only MLS, by the way, that requires that. There's several others that do. Scott, you have anything to add?
Well, I guess that's interesting. I mean, it is clear cooperation that would invoke that you would have to list it because if you're listing it on another MLS, it's not in that region, then you're publicly marketing it. So that is ultimately, I guess, what would invoke that. But and maybe there's some additional rules. I don't know. I mean, I'll say this: from a regulatory standpoint, or from the licensing standpoint. I mean, if you were a broker and you were taking a listing that was in a geographic area and you weren't listing it on that local MLS, I think you'd have some competency questions or fiduciary questions. I think there would be some issues there potentially too. And to me, that's a bigger hammer potentially than what the MLS rules might be. Not saying that the MLS rules don't apply. I'm just, I've not
I
heard
mean,
of.
the MLS hammer is pretty big. I mean, if they wanted to, they could take away your access. I mean, that's not a small hammer.
Yeah, true. I mean, I'm not, yeah, I guess I'm just, maybe I didn't fully understand the question, but that's par for my course these days. Some things just go straight over this head of mine. Right, Damian?
I didn't say that.
All right.
So yeah,
Um,
I don't. I think we move on from that. But that's the clear cooperation we're talking about, and it's not just in PPAR. I mean, I think a lot of MLSs are going to be struggling or looking at that and figuring out what they're going to do or require, and what portals do or do not comply. So
I mean, I've been talking about this for a while. I'm concerned for MLSs in some ways. I mean, this part of they're the victims in some ways of these data wars and this aggregation and consolidation of brokerage firms. and this marketing strategy with regard to less MLS and more internal or within separate and specific networks. And I think in some ways MLSs as businesses they react too slowly. They're flat-footed. They're hamstrung in many ways by NAR policies with regard to what they can do, and so they're going to have to figure out what their value proposition is. And I keep coming back to that, particularly now. I mean, if you just assume, let's imagine a private network kind of situation where it's you're going to have a property that's going to come on the market and it's going to sit in a private network, whatever you want to call it, for 30 days, 35 days, being marketed internally. And then it's going to go into some sort of coming soon status for another 10 or 15 days. And then if at that point we're out now, 45, 50 days, if it doesn't have a contract on it, it's then that it'll finally go into the MLS. And, I look at that and I go, if I'm the MLS, I'm having a bit of a panic attack right now. And I think because of that, Zillow's having a bit of a panic attack because they're looking at it going like, listen, our feed is primarily coming from the MLS. And so, I hate to keep coming back to these data wars, but it is so, it's such a topic, and it's to my mind the hottest topic that we're going to be having in our industry discussions over the next 12 to 18 months. I'll say that, and I don't. Well, I'll get us probably off track, but I'll mention that MRED thing, that MLS in Chicago, or it's a Midwest Data, whatever it is that acronym stands for. I mean, again, a massive MLS, and what their deal with Compass was, and the reason that Zillow is now suing them is that Compass went to MRED, or maybe I don't know who went to who, but basically they said, hey, we're going to take any of Compass's private listings and we're going to put them on MRED so that you can make those would be available to anybody who's a member of MRED. And MRED then went and said, we're going to open up our MLS and we're going to allow whoever wants to join, no matter where you are in the country, is free to join MRED. And so any broker on this call could join MRED. And now you would have access to the private listings that are placed there by Compass. And I think they're doing the same agreement with, I think I've heard Bright. I think there's 4 or 5 large regional MLSs where some of these agreements are going into place. But what does that mean for you guys as brokers? It means that, whereas 15 years ago, 5 years ago even, maybe even 3 years ago, you could wake up in the morning and go, hey, I want to see everything in my market, everything that's listed. And you would go to your MLS, you'd log in, and you could be damn sure, at least 99.9% sure, that everything that was available for a buyer that you're working with is going to be right there, and you're going to have access to it and you're going to see it. Well, those days are over. I mean, from any meaningful standpoint. So what does that mean? It means that, well, you might have to join your local MLS, but you might also have to join MRED or some other, and who knows what these other merged companies now with, Next and EXP and Real and Remax, like, are they going to set up their own? Will RE Colorado now become a regional MLS for the private listings of some other entity? It's going to be fascinating to watch. That's the only thing I can say, is that we're in this business at a really, really exciting inflection point for the purposes of new business models and a lot of stuff happening.
And there's a lot of money on the line because everybody keeps suing each other.
Correct. Absolutely. Yeah. Compass had sued Zillow. That got dismissed, I think, correctly. And Zillow was found, it was dismissed in Zillow's favor. And now Zillow's turning around to sue Compass and MRED both. So yeah, there's a lot of headbutting going on in our industry. I did get us off track.
No, that's okay.
Good info.
I don't know as we had a track. I think we were
That's
kind of
true.
going into it anyways.
Flight of the Bumblebee. You want to jump into your next topic?
Yeah, I want to kind of talk a little bit about, and Scott disagrees with me, and maybe some people on here can comment, but I mean, I am starting to hear that there's more short sales and foreclosure stuff coming, and I know that the administration just changed some of the rules that were in place that came from COVID about what you had to do to foreclose, and that's making the path to foreclosure a little easier for some of the banks and people that have been behind. I'm hearing that the short sales as the market has kind of shifted a little bit. We're seeing more and more short sales of people that bought their properties in the last 3-4 years that paid more than what they're worth now. We're seeing, And I just want to make sure that, because a lot of people did not live through the Great Recession, which I don't wish that on anybody. And for those of you that are on here that did live through it, I'm sure you still have a little PTSD from, doing short sales and foreclosures. But, I just want to remind people that, there's some things about the short sales and foreclosures that if you haven't done one or haven't done one in a long time, you might want to go get a refresher or as we start to see more of these, or if we see more of these, Scott's not convinced that we're going to, but I'm always doom and gloom, Scott. So I know that's hard to believe, but I think we're going to see them. But you're going to need to make sure that you know what you're doing with them because they are a different beast, and the sand has shifted a little bit on them too. Short sales, just real quick. If you're doing a short sale, make sure you have both addendums. There's a short sale addendum to the listing contract that you need to have in place. It's essentially a bunch of warnings telling the seller about the risks and what happens with the short sale and what the consequences could be. All those kind of things that you want to go through with them and make sure they understand. The more important one though, and they're both important, but the most important one is the short sale addendum for the contract to buy and sell. I had somebody call me and talked about, hey, the lender didn't approve our short sale. So what do we do now? I said, well, that's easy. You just go into the short sale addendum, you issue a notice to terminate based on the short sale not being approved under the short sale addendum, and you're out of the contract. And they said, what short sale addendum? So, that's probably not the right answer that you want to give people that, you don't want to, oh, I didn't know that it existed, that we were supposed to be using this form. So, pay attention to that. Short sales also, from what I'm understanding, they've shifted a little bit too. And, the days of the Great Recession, there was, the foreclosing or the first mortgage that was also underwater because there was all, everything was underwater in those days. They would usually grant like $1,000, $2,000 to junior lien holders just to get them to agree to the short sale. They're not necessarily doing that now. I've heard a lot of them saying, nope, we're not going to allow you to give anything to those juniors. And then it becomes incumbent on buyers coming up with extra money or different ways of trying to get there. They're a different beast. And the biggest one is solar panels. Those have apparently become a major, major hiccup when you're dealing with short sales because the solar panel companies didn't live through the Great Recession, so they have no idea that they can't get all their money. And so they think, nope, I'm going to hold out for everybody to give everything. And then some of those properties end up going to foreclosure. So just something to keep in mind. If you start seeing them, if they start becoming a part of your business, just make sure you're taking some education or getting familiar with those forms again and understanding what you have to do with them because, it is a little different than it was during the Great Recession. And a lot of you just haven't seen them in a long time. The other one I want to talk about is the Colorado Foreclosure Protection Act, because this is another one we haven't seen in a long time. As I talked about, the Colorado Foreclosure Protection Act is a CCPA claim. So again, consumer protection, attorney fees, triple damages, up to a year in jail, no E&O coverage. And I think what gets everybody really confused is the fact that, it's in foreclosure, so I, as the listing broker, need to use the Colorado Foreclosure Protection Act form. That's not the case. That is not the person that's responsible for it. Now, I'll give you some background just so you understand why. Is that when the Colorado Foreclosure Protection Act passed in 2010, it was akin to the Dodd-Frank Act. It was, again, the legislature closing the barn door after all the cows had left. And essentially, they put together this to say, hey, we want to protect sellers that could be victims of being in foreclosure. And we had these equity purchasers, we had these foreclosure consultants, and we had these people coming out of the woodwork that were kind of taking advantage of sellers that were distressed because they were facing a foreclosure. And so knowing that that's the backdrop of this bill is to protect sellers, would it really be in the seller's best interest to tell every buyer, hey, I'm in foreclosure. Would you like to come beat me up and take advantage of me and maybe take some of my equity away from me? I mean, that's just not what that bill was made for. So listing brokers, that is not your responsibility to disclose that the property's in foreclosure. In fact, I would submit that it's probably a violation of your fiduciary duties if your seller has not specifically directed you to tell people that you're in foreclosure. So that's not your job to make sure the right form is used. It's actually a buyer agent job. So it's the buyer agent that's responsible, or the buyer broker that's responsible for making sure that the form is used correctly. And I'm not going to go through the full legal analysis or everything else about when to use the form. There is actually a fantastic worksheet on the Division of Real Estate's website that is outstanding, Scott. It is outstanding. And
Did you help write it?
yeah, I
Who
wrote
wrote
it.
that worksheet, Damian?
And apparently my intellectual property, it's okay to keep using it on the division's website, but that's another story. Um, but it has this flow chart about when to use the form, guys, and that's really the important thing. I'm just going to say this. If your buyer is not going to live in the property as your principal residence, go look at that worksheet. Okay. If the buyer is not going to live in the property as the principal residence, go look at the worksheet. It's got a whole bunch of, is there equity in the property? Because there has to be equity. Is it a homeowner? Is the seller? Is it residential? It's a whole bunch of other things. But the biggest litmus test before you go look at that would be just if your buyer's going to live in the property, don't worry about it. But if the buyer's not going to live in the property, time to go double check. And the reason is because if you don't use the form, you're looking at a CCPA claim potentially, and that could be dangerous. So just something I want to point out to you there. The other thing along these lines is that, and Scott, I've seen, I'm sure you probably heard this too, is I've seen a lot more wholesalers or a lot more, what I'm seeing a lot of is these power of attorneys that somebody has this power of attorney and then they call it some novation agreement. So I don't know who the hell's teaching novation agreements because it wasn't me. But they call them novation agreements and they say, oh, I have the power of attorney for the seller and you're going to be listing it for them, but I'm the one that makes all the decisions. So there's a lot of problems there. But the biggest one is that I can't help but wonder any seller that is in a position of working on one of these where these companies are getting equity out of the property at closing, they're getting a piece of the equity out of closing for getting involved or whatever the heck it is that they're doing. Doesn't it seem like if that was in foreclosure that they're probably violating the CFPA? I think there's a real problem there. And frankly, guys, the business model is dangerous because I can tell you the Division of Real Estate is looking at those things and they do not like them. And I think we might eventually see attorney generals starting to look at this stuff too, because you could see where if you got sellers that are, oh, look, Jill found the worksheet. It's fantastic. But as you see more sellers maybe being harmed by this, or, because a lot of these I've seen where it's tens of thousands of dollars that the seller gave up to some company that never owned the property. And that seems like an attorney general might want to get involved with that or wonder what's going on. And the CFPA could be a very easy mechanism for them to go after those companies based on the fact of, well, they were in foreclosure. You didn't look, you didn't know, we're going to hit you. And for all the damages that you caused these people. So just something I want you guys to be aware of when you're looking at that. And if you're representing those people, I strongly encourage you to talk to your legal counsel or your at least your employing broker about, what does the program look like? Is this somebody that's taking advantage of somebody? I mean, I have seen some of these programs where they really are looking out to try and help the seller. It's not egregious amounts of money and things along those lines, but by and far, a lot of them are just kind of questionable. Scott, you have anything to add on that?
Yeah, I was just taking copious notes, Damien, learning at your feet here. That was no, I mean, I'm so my belief is we're headed into a market of lower interest rates and a real estate market that just catches fire and escalating values and better inventory balance and all of the good things. My glass is half full, Damien.
How can you
Um,
be a lawyer and be half full? That's not possible.
there's a lot of people that question if I'm actually a lawyer, so you wouldn't be the first, but I am. Um, the No, I would just highlight a couple, I mean, well, two of your points in terms of the listing contract. I get that from brokers all the time. Like listing brokers panic and they go, "Oh my God, my seller's in foreclosure, but we're not using the Foreclosure Protection Act contract, and am I in trouble?" And all of this stuff, and that is not what it's intended for. I find that in most cases, people don't even consider the threshold entry into whether it applies or not, and that's whether the buyer intends to occupy it as their primary residence. So that's the easy trigger. But still, it's a question that comes up a lot, and I think you made the point that disclosing that would be. I mean, I think it is defined as we've been talking a lot about confidential information as it relates to informed consent and everything else. I mean, that's a motivating factor for a seller, which is specifically defined as confidential information in our listing agreements. And so I think even though it may be publicly available, if an NAD has been filed and somebody could go find that information, it's the investor who's scrolling the NED filings. That's who is really targeted by the Foreclosure Protection Act to protect the seller from those sort of, call it, predatory investors that are. So most of your sophisticated investors or buyers who it might apply to are probably going to be knowing already when they write the offer that it's in foreclosure. But anyhow, it's not a
I'm
listing
not sure
broker's
that's
job.
true because a lot of them are coming in from out of state, and I don't think they pay attention to the
Yeah, that could be too. That could be too.
sound.
And then yeah, just the wholesaling thing. I mean, I'm hearing about it a lot more. It's not illegal, but I don't know any other way to describe it other than it's equity skimming, right? I mean, that's the entire point is that your seller. So I look at it on two sides. If you're working with a buyer, I would be dubious, leery, make sure that you're not doing anything that is going to be harmful to a consumer, or you're facilitating behavior that a buyer wholesaler is going to be that might be harmful to consumer because you could easily get tapped into that. If you're going to work with a wholesaler, then you better darn well have language about assignability and, I don't even know I don't even know what happens with the brokerage relationship in that standpoint. So let's say your wholesaler assigns it to some third party. Are you going to show up and close it? But you don't no longer represent the buyer if you got
You
a
got to
brokerage
have,
relation.
and if you assign it to somebody else, does that mean when you assign it that their broker now gets paid because the contract says that the broker for the buyer gets paid on the transaction? I mean, the
Yeah,
assignment
if you're
stuff is dangerous for a numerous number of reasons, but that's that. And I think if you're working with anybody like that, you're going to need an attorney to draft a whole bunch of provisions. One, for how the assignment goes to the new buyer, but two, how does your commission work and how do you get paid on that transaction?
yeah, and what's your brokerage relationship with buyer number two, or do you have any? Who's going to sign that settlement statement on behalf of buyer numbers? It's anyhow. I don't love it. I know you don't either, and that's on the buyer side. On the seller side, if you're getting these offers from wholesale buyers, I think it's incumbent upon you to help them understand that. My guess is two things. One is the contract to close rate, the percentage of those contracts that actually end up closing is substantially lower than than a normal sale.
Yeah, they have no skin
Because
in the game. They're looking for
correct.
another buyer.
So they either find another buyer, they terminate the contract and get their earnest money back and move along. So I think your seller's got to be aware of that, number one. And then, like I mentioned, your seller needs to understand that the entire point of this is some form of equity skimming. In other words, they believe that your house is worth enough more money than what you're going to go under. They're going to go under contract at that they can get a little bit of a windfall by turning around and selling that contract to some third party. And any if you're like I say, if you're a listing broker, it's not that they're illegal. It's just that I do think you have from a standard of care standpoint, have an obligation to make sure that your seller is very aware of what that transaction looks like on their end, because I guarantee you the vast majority of them will have no idea what a wholesaler is, how the deal works and what the implications of all that are.
Yeah, and for the love of God, get in writing if they decide to move forward, because you don't want to be the one left holding the bag when they decide that they made a bad when. And what I've seen is it's not necessarily even the seller that thinks they made a bad decision; it's their heirs that think they made a bad decision and want to sue you.
Yeah. Yeah, that's a good point because again, they're like, wait, they sold it for what? And yeah.
Yeah. So yeah, be careful. Um, we had some other stuff, but I think we're coming up on time. Oh,
Any
some
questions in there?
Um, let's see. Rhonda says, so if my sellers are in foreclosure and we have not disclosed that fact, is there any point when we would need to disclose to an owner occupant buyer?
no.
Yeah. Well, if the foreclosure sale was scheduled prior to the closing date.
Yeah, I mean, yeah, you're right. Yeah, if it's scheduled, if the closing is scheduled after the foreclosure date, then you got a problem because you're not going to be able to convey the property. So that would be a material fact. But I
They're
don't
also
Well,
see
going
that's
any
to
what I'm
reason
give,
not to
saying.
they're going to
convey
see
it.
the NED
Yeah,
on the title commitment.
but I don't think the listing broker. It's incumbent upon them to disclose it. If it shows up and they see it, they see it. And that just is what it is. The only time that I think a listing broker should be disclosing that a seller is in foreclosure is if you're up against that deadline, the sale date, because they changed redemption and cure. They're now the same period before the sale date. So once the seller goes past the sale date, they're out. They got no more rights in the property. And there might be juniors that have some redemption rights, but the seller is done. The homeowner's done. And so the only time that I think it would be worthwhile for a listing broker to disclose that a property is in foreclosure is if they're up against the deadline, like it's in 3 weeks, maybe even 4, and you're not sure that you can get a contract fast enough. Then I would get permission from the seller to disclose it in order to try and fire sale the property, because getting some equity is better than getting none. Now, if you're 60 days out or got abilities to postpone the foreclosure sale because the bank's lawyer says they'll work with you or something, then I'm not sure I would do that, because you're going to hurt the seller's equity if you disclose it.
I think that's essentially what I was saying, Damian. To the extent that the foreclosure implications are going to have a come get crossways with the closing date, then it's something that should be disclosed.
Okay. I'm sorry. I thought I did a better job, but hey, this is our first rift. This is our first tip we're having. We might need counseling.
Yeah. No, I
Okay,
think we're on the same
Nancy
page there.
S. There is a rumor that PCOA security deposit 2 times rent cap is being discussed and may no longer apply.
It's done. I'm not allowed to step on Brian Tanner's fire for next month, but since who was that? Nancy that said that or
Yeah.
asked that? Well, then
I
yes,
think
it's that.
we could probably address that. I mean, there's a lot to talk about with the sunset bill and everything else, so we could probably address that a little bit.
Well, yeah, no, and it's a great point. It's been that's done, been signed by the governor. I think it passed the Senate unanimously, both which is crazy for our legislative world these days. But yes, that was a bill that Carr ran, and so essentially what they did was they exempted the post-closing occupancy agreement out of the landlord-tenant, or out of the statute that basically said that a security deposit in a residential occupancy agreement can be no more than 2 times monthly rent. And so security deposit, so PCOAs are no longer part of that. They're specifically exempted. Now, be clear on this. That will not go into effect until January 1st of 2027. And that was at the request of the Division of Real Estate, which was perfectly reasonable. And they just didn't want to update the forms. And so that is already done, signed by the governor. No looking back on that. Beginning January 1st, that will no longer be the case. Now,
until then, you can't do it.
Yeah, correct. And I don't know if Damian and I need to get into both of our thoughts. I think we share the same mind with regard to, I never minded this as much as the entirety of the brokerage community seemed to, because I'll tell you, being a landlord in the state of Colorado is really, really, really tough. And that's all you are under a PCOA. The buyer is a landlord, and they're not a professional landlord. They don't know what the hell they're doing. And the number of times that I used to see or hear about where buyers would close on a property, they'd do a month-long PCOA with a seller who was a tenant. Seller would move out, buyer would go to take possession, and all the stuff was now gone. And the buyer would say, "Oh my goodness, the seller never disclosed this, stain on the floor underneath the dining room table, or there was a rug covering this. We never saw this." And so the buyer would turn around and say, "I'm not returning." It wasn't clean enough. Whatever. And the buyer would turn around and say, "I'm not releasing your security deposit." Or I'd get a call from somebody saying, "Well, my buyer doesn't want to release the security deposit. Do they have to?" And I'm like, you don't understand what a security deposit is for. A security deposit is for any damage that occurs literally from the moment of closing through the moment of possession. It's not stuff that was undiscovered in the contract or based on the contract and the language that might say that seller agrees to have it professionally cleaned. It's not on that. It's for damages that occur during the tenancy, right, which is after closing. And the thing is, and it'll be right back where we were after January 1st of next year, when your buyer who confidently withholds the security deposit or some portion of it for damages that they can't prove when they occurred, or damages that were directly related to the contract, like Damian's point, if it wasn't left clean enough. I'll tell you what a smart seller tenant will do is they'll say, "Okay, I'm not getting it back," and they'll wait for 30 days. And then when they don't get a full refund of their $1,500 after 30 days, they will go and sue the buyer in county court under landlord tenant theories to say, "You wrongfully withheld my security deposit. And not only am I entitled to the $1,500 back, but I'm entitled to $4,500 back because I'm eligible for treble damages."
And attorney fees.
And attorney fees. And And so I've never loved, particularly again, in the Colorado that we now live in, where being a landlord is a really, really heavy lift. It's not easy to do. Some non professional landlord buyer who thinks they understand landlord tenant law or understands what they can use the security deposit for to even have a security deposit. So, you know,
Yeah,
your clients.
maybe us talking about this before Brian got on is better, but I'll tell you guys the other thing that for those of you that took the annual commission update course already this year, legislature passed a redefinition of what normal wear and tear is under the statute. It's no longer under case law anymore, and it is a lot broader scope of what normal wear and tear is. So now you got buyers that aren't allowed to charge for normal wear and tear. And by the way, that's cleaning. Almost across the board, cleaning you cannot charge for. And so you're going to see buyers just sitting there going, "Oh, well, I don't like how they cleaned this, so I'm going to keep this." And you guys better be advising them that, hey, if you want a security deposit, that's fine, but you need to understand that you're going to have to return it within 30 days, and you're going to have to return it within the course of Colorado law, and there's requirements that you can't withhold for normal wear and tear, as well as a bunch of other things. Otherwise, it could be subject to treble damages. I'm with Scott. I just don't think this was worth it. I don't think you guys should charge security deposits because your buyers don't understand it, and you guys are the only ones that they can blame for it when it doesn't work out for them.
Well, and you're also the ones that they ask a question to. The buyer goes to move in and they're all excited. And they're like, holy crap, look at this. And they call you and they go, can I keep the security deposit? So they're looking for the legal advice related to that from you. And so, you know, uh, don't call the legal hotline. Don't, I guess, the only answer to the buyer is if you want to keep the security deposit, please contact an attorney and get some proper legal advice with regard to what you can do or can't do. I just don't see another answer. Anyhow, with that said, I do know that are few issues that have sort of roiled the industry as much as this whole security deposit and PCOA things. I heard so much about it for the better part of a year after it first went into place, but it is going away January 1st. And so you can collect all the security deposits and no rent that you want on behalf of your buyer can collect all the security deposit and no rent if they want going forward, but not until January 1st.
Yep.
There was a question going back to the wholesale contracts. How easy is it to terminate a wholesale contract as a seller? Typically, it is hard to terminate as seller.
I have no
Any
idea.
contract's hard to terminate as seller. I mean that
Yeah,
the
that's not a state
contract is
approved form.
well, or what I find is that they use the commission approved form and then they use an addendum, like a wholesale addendum or something. But I mean, as anybody on the call knows that, there's very, very, very narrow termination rights in the commission approved contract to buy and sell for a seller. The contingencies and rights to terminate are, 98% of them are buyer rights, not seller rights.
Yeah, and there might be something, and the reality is they're usually going to have something drafted by an attorney to, the sophisticated ones will have something drafted by an attorney that will have no outs. And I, either way, it doesn't really matter whether there was outs or not. This is a question for the seller to go get legal advice. But more importantly, hopefully you guys are advising them before they sign one of those things and helping them understand what exactly they're getting themselves into.
All right. I think that's all our questions, and we're past our time. So we'll wrap
Whew.
up there. Thank you, gentlemen, so much for all that great information. Thank you, everybody, for spending part of your afternoon with us. It was great to have you here, and we will see you next month for our industry update with Brian Tanner.
Thanks, everybody. Have a
Okay.
great Memorial Day
Thanks
holiday.
again. Yeah, have a good one.
Thanks.
Have a
Thank
great long
you.
weekend, guys. Okay, we'll see y'all
Bye.
soon.